are continuing our series where we are breaking down the differences in family law state by state. And today I have a family law attorney with me, and he is an attorney practicing in North Dakota and Minnesota. His name is Travis Jung. Travis, can you introduce yourself and your firm?
Sure. My name is Travis Jung. I'm an attorney with Jesdal Law in Fargo and Moorhead. We're a firm that practices exclusively family law, and have been doing so for about 35 years.
Awesome. Thanks for joining me today. I've found it so interesting talking to attorneys from different states and learning how different the family laws are state by state. So let's start out by talking about rights for people who have kids out of wedlock. So let's say a husband, or not a husband, a girlfriend, boyfriend, they're dating, they get pregnant, they have a baby. What rights do mom have and do dad have to that child out of wedlock?
Well, the safest thing, of course, is to immediately sign an acknowledgement of paternity. Obviously, it's a lot easier to determine who the mother is, but not as easy to determine who the father is. So, and I've actually had kids in both North Dakota and Minnesota, because we moved from one city to the other in between my first and second child. And it's the same as probably most hospitals. They hand you paperwork. It's called something different in North Dakota than it is in Minnesota, but it essentially does the same thing. So long as the dad who's there at the hospital and the mom both sign off on it, you've got rights immediately in North Dakota. But I do believe that it's a little bit different in Minnesota, where if you do not have paternity established or adjudicated in Minnesota, that it's presumed by statute that mother has sole physical custody until you actually go through that process. So a little harsher in Minnesota than North Dakota. But there's other levels too. You can be a presumed father. You can be the alleged father. There's all different levels of claiming to be the father of a child, but the safest bet is to be adjudicated through a court order or have a signed and filed acknowledgement of paternity.
So if the dad in North Dakota or Minnesota, if the dad's on the birth certificate, say the parties agree, he acknowledges paternity at the hospital and he's on the birth certificate, does that grant him legal or physical rights to that child? Or does he still, I would assume that he would still have to file a petition to get that laid out in a parenting time, but does the law look at him equally at that point because he's on the birth certificate?
In North Dakota, yes. And don't quote me, but I think you have to go an extra step in Minnesota. But you're right, it doesn't talk about custody or parenting time or any other parenting provisions. You actually have to go through the court through a paternity petition to get parental rights and responsibilities laid out and parenting time and those sorts of things.
Yeah, so that's interesting. So here in Georgia, we are actually the opposite. So if we have an acknowledgement of paternity, and if that's signed at the birth of the child, all that does is it gives the right for the mother to go to child support services and put him on child support. But until a father files a legitimation and seeks legal or physical rights to his child, a child is illegitimate if they're born out of wedlock. So he actually has to establish that through our superior court system and ask for, parenting time and custody. But the mom has sole legal and physical rights by virtue of the law until he does that.
Mm-hmm.
So it's interesting, but it's also, I think people need to realize that it's also just a problem of the logistics, right? So even though if you have technically, I guess you're on equal playing fields at that time, if the mother has the baby, then you might have a hard time getting parenting time until you actually file something.
Right. Yeah.
In either one of those states. is there a time period in either North Dakota or Minnesota where if the father does not try to establish rights to the child, that he might lose that opportunity? Or is the court unlikely to say, you know, I don't care if the kid's 12, you still get the right to have something to do with the child?
I believe that you can petition the court for paternity at any age, and I don't think there's a restriction. I do think that if someone else has held themselves out to be the father of the child, I think you get the term presumed father, and I believe if that's the case, that you only have 2 years until the child is 2 years old. I'm not 100% certain on those time frames, but it had something to do with if there's already a presumed father.
So it could be
And
important that someone does it quickly, right? So that they're not sitting on their rights and then realize, oh, I've waited too long.
Right.
Yeah.
Yeah. I want to say that those dates and times are spelled out in our statutes, but I'm not 100% certain on it.
Can a dad in North Dakota or Minnesota be put on child support but not have parenting time established? So not have a right for physical or legal custody, but have to pay child support?
You know, I think a lot of times the reason that paternity cases are brought is to establish child support. I don't think you can be on the hook for child support unless you have established a parent-child relationship, and that would go through that would have to be after paternity is established. I do think though that you can be on the hook for child support if you've already had a parent-child relationship established and then later terminated.
Mm-hmm.
I think I remember a case or two, or even maybe working a case where someone wanted their parental rights terminated, thinking that it would get them out of child support, but that doesn't necessarily do it. You can still be on the hook for child support for a child that you no longer have legal rights to, unless I think if there's like an adoptive parent waiting in the wings that'll support it. I think the state might let you off the hook there, but other than that, I think you can stay on the hook.
Yep. And that's pretty similar here. The court doesn't really like to terminate rights, obviously voluntarily, because they want the parent to be financially responsible for the child. But if there is a step parent involved, then that is something that the court will do and say, okay, this person is taking the place of that biological parent. Let's talk about a default custody. So in North Dakota or in Minnesota, is there a default to 50-50 custody of a true shared schedule, equal time with mom and dad? Or is it up to the judge to do what they think is in the child's best interest? Or what do you usually see around your area?
Yep, no default. I think our legislature is pretty clear that it doesn't favor the mom or the dad, and that there's no default to 50-50. So we have a statute. I'm sure it's similar in other states as well. It's like a 14-point statute. It's the best interest of the child that dictates who the parent that should have custody is best suited with.
Yeah, that's interesting. So ours is similar here in Georgia. We're the best interest standard, and our judges don't typically go with a 50-50 unless the parties agree to a 50-50 schedule here. But a lot of the other attorneys I've been talking to in other states, they actually do have a statutory default where the judge starts at a 50-50 and then has to find a legal basis to deviate from that. And they have the opportunity to do that in the child's best interest, but they have that starting point of 50-50. That's not the case here. And it sounds like that's not the case in North Dakota or Minnesota as well.
There's rumblings that Minnesota might pass a law that there's a rebuttable presumption that 50-50 custody is in the best interest of a child. But right now, we don't have, right now, there's a rebuttable presumption that a non-custodial parent should have at least 25% of the parenting time. That's a Minnesota statute. There isn't anything like that in North Dakota, but I do think that the courts will try to start parents off on equal footing. But there's definitely no default right off the bat. You've got to apply those best interests of the child factors to the facts of your case first.
Yeah. So let's shift the focus and talk a little bit about divorce. And it might be different state to state. Maybe it's the same because they're so close. But is everything if you're married, whatever you purchase during your marriage, is that considered marital, or is title important? What's the general law for marital assets in your states?
Yeah, so this is one of the big differences between doing a divorce in North Dakota and doing one in Minnesota. And what's so interesting about being in a border city is that depending on how your assets are situated, it could be a big disadvantage to file in North Dakota, or an advantage to file in North Dakota versus Minnesota, because North Dakota does not distinguish between marital and non-marital property, but Minnesota does. So if you have assets coming into the marriage, the court in Minnesota is going to try to get you back to where you were coming in to the marriage. Obviously, that gets more difficult the longer you're married and the more commingled your assets become. But in North Dakota, it's an all-in state. So whether you had it before, whether you got it during the marriage, however it's titled, it's divisible by the divorce court. So we have people that obviously can be very frustrated with that. And I do think that there are judges and there's exceptions for short-term marriages, in that, it's a lot easier if a marriage lasts for 2 years, to try to trace back and figure out what the parties had going into the marriage, and try to get them back to that spot. But no, in North Dakota, it's a pretty hard and fast rule that it doesn't matter what you had coming into the marriage or what you accumulated during the marriage. It's all in, and it's subject to division.
So do you see, that's crazy actually, but do you see more prenuptial agreements in North Dakota because that being the law, or no?
You'd certainly think so, but not a lot of lay people know that is out there. They're hearing it for the first time when they're coming in for a consultation with our office, that without a prenup, and if there's a big disparity in assets coming into the marriage, you're going to be on the hook for it, because it's all in. But we deal plenty with premarital agreements, and that's really the North Dakota divorcee saving grace, at least if you're the one that has the assets coming into it. In Minnesota, and again, this makes more sense than North Dakota's system, in my opinion, as well. But essentially, if you were to draft a prenup in Minnesota, it sort of follows the rules or the statutes in Minnesota of how they treat premarital and non-marital assets. So it's less necessary in Minnesota than it is in North Dakota.
So is inheritance treated separately? So what if someone is married in North Dakota and they get $1 million inheritance that's all put into their name while they're married, and then 5 years later they get divorced? Is that a marital asset, or would that be separate?
It's certainly an argument that we make. And in Minnesota, that would definitely, how the gift is intended, if it's during the marriage, makes a difference. But I'm pretty sure that in North Dakota, if you receive an inheritance during the marriage or before the marriage, it's going into the marital estate.
Whew, that is painful. I'm sure a lot of people do not like to hear that when they come in for a consult. So Georgia is everything that is earned or acquired during the marriage is marital. You can certainly turn a premarital asset into a marital asset because by commingling it. Sometimes there's ways to disentangle that. Sometimes there's not under the law. But it sounds like we favor more of closer to what Minnesota does than North Dakota. What about fault ground divorces? So here in Georgia, we have 13 grounds for divorces. The one that is used by far most frequently is irretrievably broken or irreconcilable differences, but we still do have adultery, cruel treatment, habitual drunkenness. We've got all kinds of different reasons that the judge can grant the divorce. What about in North Dakota or Minnesota? Are they Are they fault based? Does that even matter? What's going on in your state?
It's the same that you have in Georgia. There's a number of different reasons as to why you can, a number of different ways that you can plead for a divorce. Some of the same that you already mentioned, but I'm sure you do the same thing. It's North Dakota calls it irreconcilable differences is the catch-all that we almost always use. I think I've pled different reasons maybe 2 or 3 times in my career, but it just doesn't matter. I mean, the judge is never going to look back and see what you pled and have it make all that much of a difference. The only way that I think it does make a difference is in our spousal support. Case law talks about the conduct of the parties during the marriage, and if and this is in both states, if you've dissipated assets and essentially wasted assets called marital waste, then there is a way to retrieve that money again if it's traceable.
So ours is similar. The court can find that, if somebody, let's say somebody had a girlfriend and they bought her a condo in Atlanta, which has happened, then the judge could say, okay, well, I'm offsetting the cost of that condo because he paid for his girlfriend's condo. But what we also have is if you have an affair, so say I'm married to someone who is a very rich man and we're going to get a divorce and I have an affair, if my affair is what led to the end of our marriage, then I'm statutorily barred from getting alimony. So it's a punishment to then recoup alimony if your affair led to the end of your relationship. Is there anything like that in either of your states, or does the court not really care about the conduct in awarding alimony?
Wow, that's pretty unique. I still think the only way that it applies is, if you spend a whole bunch of money on adulterous behavior and on your on someone else that isn't your spouse, I think that the innocent spouse would be able to recuperate that, but it's really only a financial thing through the division of the marital estate.
Okay. So the last question I have is about relocation. So let's say that someone, they have a custody order. It could be through a divorce or a paternity action in either state. And the custodial parent wants to relocate from North Dakota or from Minnesota. How does that work? Do they have to give notice to the other party? Do they have to file a petition to relocate with the child? What does that usually look like?
I think you can lessen the burden by agreement if your original judgment allows the parties to relocate, but by statute, I think you need to either get the other parent's written permission or an order from the court. So 9 times out of 10, if you're trying to relocate and take the children with you, you're probably not going to get permission of the parent who's staying put, and it's going to turn into a whole separate motion. And both of our states have specific criteria that you have to meet to justify a relocation out of state. I think they're slightly different from state to state, but you've got to prove that criteria. And then again, ultimately the best interest of the child and those factors are weaving through your argument as well.
Yeah, so our judges don't typically love relocations unless there's a pretty substantial reason for that. They weigh a lot, the factor of, both parties having a connection with the child and a connection that they are allowed to see the child in a regular regular format. The last question I would ask you, I know I said that was the last one, but I thought of one more. What about elections? When do kids, if at all, get to elect in either state if they want to live primarily with one parent or the other, or maybe with joint? What does the statute in both states allow for a child's election?
Yeah, so there is no set age, but those best interest of the child factors that I was talking about, both states have one of those factors is the strong preference of a mature child. That's the terminology that they use. So is a 14-year-old mature in some cases and not in another? Absolutely. Is a 10-year-old mature in some cases and not in another? Absolutely. So as lawyers, we have to be pretty careful about bringing kids ever into issues like that and making them obviously feel like they have a decision to make is not something that we try to do very often. But if we have a strong preference of a 15-year-old or a 16-year-old, or they've got their driver's license, or they're barely at home anyway because they're hanging out with their friends, that's going to hold a lot more weight than an 8 or 9-year-old that wants to take advantage of mom and dad living in two different households and try to bend the rules a little bit more that way. But no, there's no set age. It simply says a mature child. So I personally think that once you get into the teenage years, the judge is more likely to consider that you should have a say in where you stay, just because it's a lot harder to force parenting time on a teenager than it is on a 2 or 3-year-old. And you could be creating relational issues with kids and their parents if they're being forced to spend time or to abide by a schedule that the court has set. A lot of teenagers aren't really understanding of their parents' parenting time schedules.
Yeah, I can see that creating major problems. Our statute has 2 age brackets. So ours says between 11 and 14, the judge may consider the election if the judge feels like it. And age 14 and up, the judge must consider their election. But people wait for the child, like on the day they turn 14, like here's the kid's election, so I would imagine if the statute was gray like that you would have some clients sometimes that would say, okay, I want my 9-year-old keeps telling me this is what they want. This is what they want. So that's probably a hard position to be in of, okay.
Oh yeah, we see it all the time, and it's pretty hard to convince parents that their kids' opinions on who they spend time with doesn't matter. But when you're young, when you haven't even reached double digits yet, we're very, very hesitant to even give our clients the idea that their child should be handed the keys and be able to decide whose house they're at and when. They're just too young at that age normally, unless there's unique circumstances or something.
Right. And ultimately, I could see that backfiring of the judge being upset that they were even put in that position to ask a 9-year-old to, make that election.
Oh yeah, I think I've been there before too, where you, even a 10 or a 12 or a 14-year-old, if they state a preference and then you submit a declaration or an affidavit that says that I want to live with mom, sweet. Well, then they go and they ended up meeting with dad's attorney and submit a statement saying, I want to live with dad. Well, that's sort of a telltale sign that that child is not mature enough to make their own decision, and that they are going to say different things to both parents just to appease them, or, they don't want to hurt anyone. So
yeah,
that's how we know that they're not old enough to be making that decision. And normally right around the time that they get their driver's license or they're out of middle school, their opinion means a lot more to the court.
Yeah, definitely. Well, it's always interesting learning about the different states and how some of our laws are very similar and some of our laws are very different. But I appreciate you taking the time to